Hello friends, I'm back again. Today, we will talk about some complex but interesting concepts that lawyers or contract specialists are expected to assess and advise on in every contract. Hope you were able to watch the previous sessions since those might help a bit to understand this one. It's important to remember while reviewing a contract that, out of the many purposes of a contract, an important one is to provide for the worst case scenario as to what happens when the parties cannot get along or one of them fails in their duties or promises, which leads us to the next and very important topic, repercussions, which can be of different types. Regarding monetary repercussions, the topics of indemnity, liability, insurance are subjects that we continue to learn and improve on at every stage of our careers, even after many years of reviewing contracts. Indemnity was a dreaded topic for me for quite some time in the beginning, until an extraordinary professor during my Master of Laws at National University of Singapore taught us the basics in a wonderful manner, for which I will forever be grateful. Now, obviously, I'm nowhere close to him, but I'll try my best to make it easier. For this session, I will oversimplify to get to the essence of it, and then we keep learning step by step. Simply put, if someone doesn't do as they promise, we expect that 1. They will be responsible for it, which is their liability. Second, we would be compensated for it, especially if we suffer due to it, that is indemnity. At the same time, we do not expect that someone will be responsible to an endless limit for all the consequences, down the chain or by ripple effect. To bring certainty into commerce and business, that liability usually needs to be limited to a certain extent or boundaries drawn around it. Insurance we have probably seen in personal lives, so we understand this better. Insurance is when we try and cover risks that are high in financial exposure or likelihood by asking an insurance company to pay for claims to a certain extent. If the incident happens, it will reduce our exposure. If the incident doesn't happen, we still pay certain amounts called premiums towards covering that risk, and we are probably happy that those dreaded incidents did not occur. There is a lot of confusion in the business world around insurance and liability. People sometimes think that taking insurance means liability is covered. But while there is a bit of an overlap, they are actually two separate concepts. Liability would still remain, as per the contract and law. Insurance might just make it easier and bring in a level of comfort and certainty that the responsible party can properly rely upon the insurance company to pay out claims, while keeping in mind that it is not foolproof, since every insurance policy has exclusions from the scope of what it covers and claims can be rejected as well. These topics are heavily related, of course. We cannot look at one without the other, especially liability and indemnity. Now let's take an example. A landlord might state in a tenancy contract that the tenant should ensure that the building safety requirements are followed, failing which the tenant shall indemnify or compensate the landlord. In the same example, the tenant might wish to limit their liability, saying it cannot be beyond a certain dollar amount. And the tenant might not want to be liable for indirect damages or losses either. As a counter, the landlord might say that these limits and exclusions are not acceptable because the tenant's negligence could lead to damage of the entire building. Also, the landlord might say that the tenant should have insurance in place. As a further response, the tenant can counter that the landlord should have in place insurance for the entire building, while the tenant can take care of the contents insurance. The tenant might also try to define the situations in which it is liable, or at least exclude from its responsibility the situations where the landlord or other tenants are at fault. That's what we would do in any situation, right? Even when we accept responsibility, we would say that this is not due to me or not within my scope. But the difference is that contracts may not always be so fair because they are more about risk management. And one party may pass on even its own risk to the other. The important thing to remember here is that in every situation, the discussion is different. It's contextual, based on the business arrangement, negotiation power of the parties, the dependency of one party on the other due to the options in the market, etc. For example, you might be reviewing a contract which brings in revenue for your client in a difficult market. For that business, they might be willing to take on more risks. Even when your client is on the other side of the table and is the customer utilizing services of a vendor, and in this case, not getting money but paying out, maybe they are up against a technology giant who provides a unique software which your client really needs and cannot get it from anywhere else, or maybe if they can get it, the price difference is too high. This we can only learn through experience and transaction-specific conversations. You can see this conversation in the tenancy contract example that we took is also very contextual. It revolves around the nature of the arrangement, and the same conversation will not apply as is for another type of contract. You should also know the difference between B2C and B2B. B2C is business to consumer, where the end customer or individual might not have the scope to negotiate the standard contract or terms and conditions. For example, for a loan with the bank, or for an e-commerce app usage, or even a tenancy contract. On the other hand, B2B is business to business, where these same companies, like banks or e-commerce platforms or landlords, might let the business party negotiate. But the idea at this stage is really just that when you start to review a contract as a first-time reviewer, you should be able to identify these clauses and then try and reduce and limit the situations in which you compensate the other party and are taking on liability by including relevant limits and exclusions. You can now try and think about indemnity, liability, and insurance in the context of the example we shared in the last session for a service contract for equipment maintenance service. Do let me know if you have any questions there. Another type of repercussion is specific relief or injunctions, which means to ask the court to make the other party do something or stop them from doing something. A standard example of this is when there is a confidentiality provision and there is breach of that. One party might ask the court to require the other party to stop disclosing the relevant information. Yet another type of repercussion is termination of contract due to breach or suspension of services or contract. This does not mean that indemnity and liability will not apply. A party can have multiple recourses in the case of a certain incident or trigger. We will talk about all of these in increasing level of detail and complexity as we go on. I also wish to mention an important point at this stage. So far, we spoke mostly about the contract provisions, not so much about the law. So here is an important thing about the laws related to contracts. Some requirements are mandatory as per the law and cannot be circumvented. But a lot of provisions have flexibility around them and would be as per the intention of the parties. So, it's also important to understand through local knowledge and research what's permitted and what's not. That again depends on the type of transaction and the country. So, in 3 sessions, we saw what the core of a contract is. What is the transaction or arrangement? Who are the parties? Which party is doing what? In exchange for what? What are the repercussions if any of what's promised does not happen? Everything else is related to this. Every provision should be read, reviewed, and edited, linking and keeping in mind this core. Thank you for your time. I will be back soon.